been a lot of recent speculation about the Bank of New Zealand High Court application to bankrupt Mr Olliver. This video contains information to help us to clarify the facts. You might want to keep a finger near the pause button so that you can carefully read some of the information we have presented to you here. Here is what the Gulf Harbour Community Trust know and don't know. Firstly, the bankruptcy application had been adjourned to the 17th of April 2026 from a previous hearing. Secondly, the basis for the adjournment was to give Mr Olliver time to negotiate a confidential agreement to resolve the issue with the Bank of New Zealand. Thirdly, GHCTC do not know who the parties to that agreement were. Almost certainly it included Mr Olliver and the Bank of New Zealand. It may also have included the USA-based private equity company 1543 Capital and K3 Legal. We do not know. Fourthly, the BNZ application arose from a property development by Mr Olliver completely unrelated to the Gulf Harbour golf course. A bankruptcy involves a living person. You cannot, for example, bankrupt a company. The winding up of a company is done by way of a liquidation. The only two organisations that GHCTC know of that have a personal claim against Mr Olliver are the Bank of New Zealand and 1543 Capital. These claims will almost certainly be a result of personal guarantees that can be actioned because loans to Mr Olliver related companies, for example Long River, the owner of the golf course land, are in default. When such a loan is in default, any personal guarantees become actionable. Now, the hearing adjourned to the 17th of April 2026 appears to have been withdrawn. We do not know the basis for this withdrawal. There are a number of possibilities, including that the application could be reinstituted in the future if a condition in the confidential agreement has not been met. It could be that Mr Olliver offered a sum of money in full and final settlement that was accepted by the Bank of New Zealand. It could be that 1543 did a deal with the Bank of New Zealand to prevent Mr Olliver being bankrupted. We will keep everyone posted if we receive any further information. The Auckland Council claim for reimbursement of the costs associated with demolishing the burnt-out clubhouse is a claim against Long River, not against Mr Olliver personally. We understand that case is due for a further hearing this month. The council claim against Long River, assuming it is successful, will result in an attachment order being lodged on the golf course legal titles. It could also result in the council pursuing a liquidation application in relation to Long River. There does appear to be some confusion that the council was or could have been a party to the Bank of New Zealand bankruptcy application. They are not related legally in any way. The liquidators of Gulf Harbour Country Club, GHCCC 2016 Limited, have withdrawn the liquidation application against Long River. Yet the debt of around $60,000 owing to GHCC 2016 Limited is still shown in the last liquidators report. We have queried the liquidators as to why it was withdrawn but have yet to receive a response from them. GHCTC's strategy with respect to the golf course is still as per the detailed explanation on the last 21st of January 2026 GHCTC livestream and can be viewed on YouTube here. You can scan the QR code on your screen with your phone and be taken directly to the video. Finally, and in closing, we have recently become aware of a totally inaccurate rumour that GHCTC is intending to sell the 12th and 13th fairways to Hopper Developments. This is not true. As we stated in the live stream video, the GHCTC plan is to retain the 18-hole golf course. We will communicate further on these and related matters as and when facts become available. Thank you very much for listening.